want to be the generation that has to look our children in the eye and explain why liberty died. And I know that I should
rights in the United States.
Yep.
And again, I sound sometimes like I'm a little bit paranoid, but I'm not, especially when you see the kind of data that we've been able to put together to show how conservation easements are being used by the federal government and certain organizations to control large areas of land that are not necessarily for the benefit of our country. Conservation easements, what are they? They are a legally binding agreement between a property owner and what is typically referred to as a nonprofit organization, typically a land trust or a government agency. I put nonprofit in quotes because I don't believe that they typically are nonprofit. In fact, all nonprofit means is that you have to spend all the money that you bring in. But you can spend it on a lot of things, and they do. The property owner, the grantor, retains partial ownership of the property, but relinquishes the right to use the property for development.
Yep.
And this often
They're
limits
dangerous.
all development rights. So if I put a conservation easement on my property, I retain ownership of that property, but I give up the right to make decisions about how that property is ultimately going to be used.
Yep.
Conservation easements are a contract. How they are interpreted and enforced will depend upon the language that is used. I have brought quite a few different sample conservation easements that I just pulled off of the Carbon County website a couple of weeks ago. The most recent one in here is from February of 2015. And one of the things that strikes me about these conservation easements is they're typically about 30 pages long, single-spaced, very complicated, a lot of legalese. I can assure you as an attorney, I know how contracts like this are used. And anytime somebody comes to you and wants you to sign a 30-page contract, you probably want to think twice about doing so because it's probably not going to be in your best interest for a lot of reasons. One is whoever wrote that contract, it is written to their advantage.
You betcha.
And if you sign that agreement, regardless of how one-sided it may be, it will be enforced according to its terms. Courts will enforce those contracts, even if you say, but I didn't understand that's what it was intended to do. The law specifically states that if you sign a contract, you are tasked and you are obligated with finding out and knowing what is in that contract. They are usually they are fully transferable by the grantee, meaning that they can be sold to another organization.
Yep.
Now there's a couple of different land trusts that get very angry at me. One of them is the Wyoming Stock Growers Land Trust. One of them is the Nature Conservancy. I'm not on their Christmas list, other than maybe perhaps for a small piece of coal every year. And this is one of the things that they get mad at me about. And they say, we cannot transfer these to somebody else unless we have permission of the landowner. You have to have permission of the landowner before they can transfer these. So for example, if the Nature Conservancy buys a conservation easement on your property and they want to transfer it to the federal government, what they'll tell you is they have to have your permission in order to do that. Hogwash. That is not true. By the contracts themselves, they specifically state that they may have to give the grantor notice. They might have to give the grantor information about the transfer. But ultimately, if the Nature Conservancy wants to transfer that conservation easement to another land trust or to the federal government, they have the right to do it. Now, here is the language that I think is where they try to argue that they have to get your permission, but I'm going to read this to you. It states that for this transfer of this easement, it states with the prior written consent of the grantor, which consent shall not be unreasonably withheld. In other words, you have to give the consent as the landowner, but you cannot unreasonably withhold it. Okay, well what does that mean, right? It's not being unreasonable, I'm just withholding it. It specifically states that if the grantor unreasonably refuses to approve the transfer, the grantee can go to court
Yep.
and force the landowner to approve the transfer. So even though they will tell you over and over again, and this language at least says that they have to get the consent, but it can't be unreasonably withheld. Yes, sir?
So is this something they tell people ahead of time to make the contract seem less onerous than they actually are?
Yes.
Is that the point of that?
Yes.
Exactly.
So what ends up happening is that you have the Nature Conservancy come to your house, and they say, you've got a beautiful ranch, and we want to put a conservation easement on it. And we think that that conservation easement could be worth $3 million. Plus, you're going to get tax write-offs, and you want to be able to keep your family on the ranch into perpetuity, and it's going to be such a good thing, and it's such a good idea, and you're sitting there thinking, I've been broke my whole life. The idea of getting $3 million and I get to continue to farm or ranch my property, that's a great idea. And then pretty soon they start bringing the contracts out, and they give you these. And as I indicated, they're complicated, they're full of legalese, and they have a lot of landmines. But one of the things that is very important to understand, that if you enter into a conservation easement, you may end up with a partner that you not only don't like, but that you despise.
Yep.
And they will, for the rest of your life, for as long as you own that property, be able to dictate how you use it. And I'm going to explain how they do that. Typically, conservation easements run with the land, and they are binding on all subsequent purchasers and heirs.
Jeez.
They are held in perpetuity, and all future landowners of the easement are bound by the terms of the deed. So what does that do? It decreases the value of your property as soon as you put a conservation easement on it. Tax incentives. This is where they talk about the tax incentives, and you hear about this all the time, that it is a great idea to put a conservation easement on your property because it will reduce your tax burden, your estate taxes, that sort of thing eventually, because it is going to decrease the value of your property. Now I want you to think through that. And I'm a homeowner, and I like it when the value of my home goes up, because that means that I have an asset that's worth more today than it was 6 months ago. And at some point, if I want to retire or I want to sell that property, that's a good thing for me. Keep in mind, the very purpose of a conservation easement and the tax incentive is that it decreases the value of your property. So if you are a farmer or a rancher, it decreases the most important asset, the value of the most important asset that you own. Now, why in the world would you do that? And in fact, that is the very purpose of the tax benefit that you get. The tax benefit that you get from a conservation easement is the value between what your property was worth before the conservation easement and the value afterwards. So if your ranch is worth $1 million without a conservation easement, and it's worth $500,000 afterwards, you can have a $500,000 tax benefit. Well, I'm going to say a couple of things about that. To me, that's absurd. I cannot imagine taking the most important asset that I have and devaluing it by signing a contract. But the second part of it is that they are intentionally designed to devalue your property. That's what they're created for. Now, what kind of implications does that have? It has all kinds of implications for when you attempt to sell the property. And before we get into the specifics of that, I want to talk a little bit about some of the statistics about the land ownership in the United States. I was asked questions about this earlier. Right now, the total land base of the United States is 2.27 billion acres. The federal ownership of the land in the United States is 653 million acres, and it's 29% of all land. So the federal government right now owns 30% of all the real property in the United States. Approximately 605 million are owned by the BLM, Forest Service, National Park Service, and the National Wildlife Refuge. And as of March 31st of this year, there was an article showing that the National Park Service alone suffers from an $11 billion backlog of unfunded maintenance. So what's my point about this? You've got a federal government that does not have the money right now to be managing the resources that it already has. So why would it be looking at expanding and taking control over more and more of our land and our property in the United States? Wyoming has a total of 62 million acres. Federal and state ownership combined is 33,964,000, right at 50%. Right at 50% of our surface estate is owned by the federal or state government. That does not include easements, water rights, and other types of property interests. That is enough, and I believe that the remainder of our state should be managed for multiple use. Now, what is significant is a couple of years ago, the state of Wyoming adopted a whole statutory scheme where the state of Wyoming is actually funding conservation easements. I testified against that bill and argued that when you have 50% of your surface estate already controlled by the government, the remaining 50% should be available in the long term to make sure that we can meet our other demands. We can build schools. We need land for industrial purposes. We need land for mining, for our oil and gas industry, for expansions of our municipalities. But the state of Wyoming actually funds conservation easements. I think it's a very bad idea. Private property is now competing. Look at the demands we have. Farming, ranching, industrial, commercial, housing development, mineral extraction, oil and gas, recreation, schools. 50% in the government's hand is truly enough. Now, what are land trusts and what's been going on with them? You can see that there's been a huge increase in land trusts in the United States. In 1950, there were 53 land trusts. By 2010, there are currently 47 million acres of land controlled by approximately 1,700 land trusts and similar entities. Where does the vast majority of their money come from? The government. The key to economic prosperity in this company is the key to economic prosperity in this country is pretty simple. And it's something that we've known for a long, long time. It's basically three things. Inexpensive housing or affordable housing, affordable energy, and affordable food. And it's one of the things that has set our country apart in terms of our ability to innovate, our ability to grow and prosper, the importance and the protection of our middle class, and all of those things. The ability to protect our environment is dependent upon our economic prosperity. And it's one of the interesting things about the idea behind conservation easements, because conservation easements are designed by their very nature to affect all three of those things. It increases land prices, it increases energy costs, and it increases food costs. You see that in places like California. There are massive areas in California that are subject to conservation easements. And there's a lot of reasons why you see housing costs and those kinds of things in California to be so expensive. But one of them is conservation easements. Perpetual conservation easements negatively impact every single one of these factors. In 2011 figures, more than 10 million acres were placed in land trusts in that 5-year period. There's been a 731% increase in acres in Wyoming in that same period. Now, these are some comparative numbers to think about. The total size of Massachusetts is 5 million acres. Maryland is 6.3 million acres. Vermont is 5.9 million acres. And the total size of New Hampshire is 5.7 million acres. You can see the potential economic impact when you're putting a conservation easement on that large of a swath of land in the state of Wyoming. We are federalizing, and this is one of my biggest concerns, we're federalizing our private property rights. How do we do that? We're allowing government agencies or nonprofits to be making decisions about land use. We are slowly but surely allowing the federal government to take our private property rights by tolerating perpetual conservation easements. What is meant by perpetual? In the state of Wyoming, it means 999 years. So if you put a conservation easement on your property today, it will be in effect for the next 1,000 years. This federalization is taking place largely under the radar. What a lot of people don't understand is that this funding is coming from the federal government. Now, why is the federal government funding these things? Just like we were talking about earlier, it's about control and it's about power. The federal government is recognizing that people anymore are not tolerating or as tolerant of the federal government continuing to expand its acreage base. Through funding conservation easements, they are able to control land use using the IRS code, because it is the IRS that dictates the rules and regulations for conservation easements. Think about that. The IRS is dictating land use policy in the state of Wyoming through conservation easements funded by the state of Wyoming and the federal government. That is not a good situation for any of us. The Wyoming Stock Growers Land Trust actually has the USDA as the enforcement authority. So if you and I enter into a contract for me to buy your car, and I don't pay you the money, you sue me for breach of contract. But he doesn't get to. He doesn't have standing to sue me because I failed to pay for your car. Under the Wyoming Stock Growers Land Trust, if I go out there and I put a conservation easement on my property and I violate that conservation easement by putting up a fence where they believe it shouldn't be, the United States Department of Agriculture is the enforcement authority. It's no longer a breach of contract between the Wyoming Stock Growers Land Trust and little old rancher me. It is the federal government coming in with all of its resources, all of its money, all of its power, all of its political capabilities to come after me. The Wyoming Stock Growers Land Trust, the enforcement authority, is the United States government. The Colorado Ag Land Trust has exactly the same kind of language. It is the USDA that can enforce these land trusts. Show me the federal money. The American Farmland Trust, $1 million annually from the federal government. The Conservation Fund, $3 million annually from the federal government. Nature Conservancy, $100 million annually from the federal government. What do you think the Nature Conservancy is doing? They're carrying out all. Their dictator, if you will, is the federal government. Whatever the federal government wants, the Nature Conservancy does. Now, one of the things that's interesting is you may have heard about flipping, and there is a situation where I talked about earlier that the grant that do not interfere with conservation values of this property. Period. They won't do it. I said, if your point is to protect farming and ranching, put a period right there and get rid of that last clause that's underlined, and they won't do it. So what does that tell me? That might really for potential future use. Conservation easements devalue your most important asset. It decreases your borrowing power, increases risk of default, risk for existing loans, fluctuating livestock commodity prices, or obtaining operating loans. They are being used to devalue and limit use on approximately 50% of the private property in the West. Here's another one that's really bad. I have just a couple of cases. Very recently came out. Most of the conservation easements have an attorney fee shifting provision. So if you have to sue me to enforce that conservation easement, I have to pay your attorney's fees. Recently one out of Connecticut, the landowner was ordered to pay $350,000 in damages. She'd done some landscaping, and she had to pay $300,000 in the trust's legal fees for enforcing that conservation easement. Also, the other thing that is happening is that several years ago, these conservation groups, these conservation easement groups, these land trusts, created their own insurance companies. So now they buy terra firma, they buy insurance, and so if they have to sue you, they have the money to enforce those conservation easements. So there's several sources of where that money can come from. The federal government can enforce the conservation easements. They've got insurance to make sure that they are enforced. And then the third way is you ultimately will have to pay their attorney's fees if they have to sue you on a conservation easement. There are additional implications. The right to make decisions regarding the use of property is perhaps the most valuable and most powerful right that we have. Several years ago, I was fighting with the U.S. Forest Service about it on a grazing permit up in the northern part of the state, and I was trying to save this guy's grazing permit. They had some issues with him. They had some problems, and he needed to fix some things. I'm not going to deny that. But it had been in his family, I think, for well over 50 years. And I mean, we were doing everything to try to save that grazing permit, that allotment. And we went into mediation. And they walked in and said, it's our property. We can do whatever we want to with it. And we don't want you grazing on it anymore. It's our property. And it struck me, they said, we get to decide what the use is. And it struck me that is the most important part of owning real property. You get to decide. You get to decide how that land is used. When you enter into a conservation easement, you are selling that right, but you're not only selling the right for you, you're selling that right to everybody who comes after you. And I know that there are a lot of really smart people in this room, and I don't mean to be rude or crude or anything else, but someday you're going to be dead. And there are other people who have to make decisions. And it isn't for us to use the dead hand from the grave to come back and dictate what a 27-year-old can do with his property. What a 15-year-old can do with his property. You know, one of the things that my dad had to look at different times when we struggled financially is I can sell 3 lots over on the west side of the property, and it won't interfere with our ranching operation, it won't interfere with our grazing, it won't impact our water. I could sell 3 lots over there, and that's going to give me enough operating capital to last another year. So conservation easements, those options are not available. They're simply not available. Almost every single one I've ever seen has a prohibition against any kind of subdivision, entirely. It reduces the pool of potential purchasers, merging the real estate brokers. You've already brought this issue up. Real estate agents don't like properties with conservation easements. They're too hard to sell. Perpetuity is a long, long time. And why would we want to manage real property in this country? Part of our liberty, part of our freedom, part of our prosperity has been because we are a country that believes in private property rights. Whether it's a half-an-acre lot in the middle of town, it's our little tiny corner lots, whether it's 40,000 acres. Our prosperity in large part has been tied to the fact that we are entitled and have the right to own real property. And part of that right is how to use it. Scientific advances cannot be accounted for. Nature affects changes that aren't predictable. Impacting on housing. It's already an issue in California where 427,000 acres in California are encumbered by conservation easements. Perpetual conservation easements impact the economic prosperity of a community both in the short term and the long term. If I were a county commissioner, I would find every conservation easement anybody was trying to get involved with. Counties make their money off of property taxes. And when you put a conservation easement on a parcel of property, you are forever identifying that land at the lowest valuation there is as ag property, at the very lowest. There is no way for that county to continue to make money off of those lands. It's going to affect our property taxes, our school funding, and this is, I think, just a really common sense thing. How would you all feel if somebody in 1642 made decisions about how you could manage your property today? Then why should we be able to dictate how people manage the property in 2196? To me, it is such an absurd proposition that I guess the ego associated with it. I have no idea what's going to happen in 2196. I couldn't even possibly pretend to know whether this would be the best way to manage this property. Yet we are saying that people today should be able to dictate like people in 1642 should have been able to dictate for us. It makes absolutely no sense from a policy standpoint at all. They're bad economic policy, bad public policy, and bad land use policy. The payments are in current value. If citizens in 2075 choose to preserve open space and habitat through the concept of conservation easements, they are fully entitled to do so, but they should pay the going rate for it at that time. The fact is that an easement that is entered into today for $1 million is going to be pennies at some point down in the future. And we're taking that entire value off of the property, right off the top. Perpetual conservation easements will impact our food supply and our food independence, as it will be too costly to raise food using 2010 technology when other advances have been made. The price of land will skyrocket, and industrial and commercial activities are going to be impacted. I think that there are some things that should be done with conservation easements. I'm not opposed to conservation easements even after everything I've said, but they shouldn't be into perpetuity. They should be one generation. You want to put a conservation easement on your property, you should be entitled to do that because that is a private property right. But you shouldn't be able to encumber it for other people. When you die, you're gone. And you should not be able to dictate how other people use that property. I have been generous and said 50 years. Most people I talk to who deal with conservation easements all the time say they should never go beyond 25 years. And if you want to re-up for another conservation easement, you can do that. But it ought to be done on a generational basis. The government should not be allowed to obtain conservation easements through prearranged flips. But I'll just make that flat illegal. It is a very untransparent way of the federal government controlling lands. No federal funding for nonprofit conservation groups. They are already benefited by their tax-exempt status, and the state should not use public funds to effect perpetual conservation easements. I think it's absolutely crazy for the state of Wyoming to be in this business, and it's a bad use of our money. Tax deductions should not require perpetuity. We should not allow the IRS to dictate land use policy. Future generations should not be burdened with inflexible, irreversible policies based on today's land use decisions, and they should be time limited, as I indicated earlier. I'll leave you with this. Great cities rest upon our broad and fertile prairies. Burn down your cities and leave our farms, and your cities will spring up again as if by magic, but destroy our farms, and the grass will grow in the streets of every city in the country.